Afternoon, everyone. My name is Barry Penner. I'm the Managing Director of the Vancouver International Arbitration Center, and I'd like to welcome you all today to our webinar and thank you for joining us as we discuss ways that arbitration can provide a meaningful and beneficial and efficient outcome for your clients in helping resolve disputes more quickly and more efficiently. Without any more ado, I'd like to start introducing our esteemed panelists that we are fortunate to have joining us today. First, it's my pleasure to introduce Yarden Gershoni. He is a very accomplished lawyer, graduate of the UBC Law School, but subsequently worked in New York City for 4 years for the firm of Sherman and Sterling. Got involved with international arbitrations, including under the ICC rules, seated in London, UK, as well as Paris, France. In that capacity, Mr. Gershoni was a core member of a legal team that won what was then the largest arbitration award in history, $2.5 billion, involving the Dow Chemical Company versus Petrochemical Industries of Kuwait. Eventually, Mr. Gershoni found his way back to British Columbia and is now practicing in Kelowna with the firm of Rush, Ihas, Hardwick, LLP. So we look forward to hearing from Mr. Gershoni. Also today on our panel, we're joined by Joe MacArthur, who's a partner with the law firm of Blake, Castles, Graydon, LLP, better known as Blake's. Regularly advises on domestic and international arbitrations as counsel, and is also available for appointment as an arbitrator. I should say that he is also chair of the board of the Vancouver International Arbitration Center, and it's been my privilege and honor to get to know him and work closely with him over the last number of years in that capacity. And he is joined by a fellow partner at Blake's, Blake Castles Graydon, Laura Kandari, who, like Joe, has been involved in a wide variety of complex disputes and commercial arbitrations. And has been very helpful to us on our board in helping work on our rules, updating our domestic rules, as well as our international rules, which will be forthcoming shortly. And Joe and her have been working hard on that to further assist our organization. For those of you that are not that familiar with us, with the Vancouver International Arbitration Center, you may know us by our previous name. We were founded in 1986 as the British Columbia International Commercial Arbitration Center. In 2020, we went through a major rebranding and became known as the Vancouver International Arbitration Center. So we're the same organization. We just recognize that the name Vancouver actually resonates more internationally than the name British Columbia. As a province, we were often confused for a country somewhere in South America. So it is the Vancouver International Arbitration Center, and we've been in business now for going on, I think it's 36 years. And we've had our most successful year ever in 2021. So we look forward to more growth, but we realize we still have work to do to make more people around the province and frankly around Canada and internationally aware of the assistance that we can bring with our 135 experienced arbitrators that are on our roster, as well as a number of services we can provide with our helpful staff that support our organization and are here to support you in your practice in handling specific questions that you have about procedures and so forth, about how to conduct commercial arbitrations. So without any further ado, I should say that as business keeping here, housekeeping, certainly we welcome questions. I ask that if you have a question, you identify that using the chat feature in Zoom. We will either get to them as we're going through. If not, I will kind of take things over at the end of the various presentations from our three panelists and put those questions to the panelists to have them answered as best we can before we conclude today's presentation. So by all means, if you have questions, please indicate what those are using the chat feature. And so at this point, I would now like to turn to Yarden Gershoni to speak to us about arbitration.
Thanks very much, Barry. That's a nice introduction. And thanks very much, Joe, Laura, and Barry, and Ina at VanIAC for having me speak today. I'm going to be giving an overview of arbitration and the basic landscape of arbitration in BC, and then going over some of the benefits of arbitration as opposed to other forms of dispute resolution, in particular court. I obviously realize, looking through the attendee list, that there are people attending who will have heard this before, to put it mildly. But to make sure that we're all on the same page, I think it's good to go over this. This webinar is at least in part geared toward making sure that everyone's aware about VanIAC's services across the province, not just in Vancouver or the surrounding area. So a bit more of my background, just so you know where I situate in this. I did practice international arbitration out of law school, based in New York, for about 4 years, mostly under the ICC rules, and got, I think, a fair bit of experience working on relatively larger files in that respect. And then when I moved back to British Columbia, I practiced at McCarthy's and practiced domestic arbitration and obviously commercial litigation, and also assisted solicitors fairly often in drafting and reviewing arbitration clauses. And now I've been in Kelowna for about 8 years, which is where I grew up in Vernon, British Columbia, so I'm close to home again. I'm still very bullish on arbitration, which you might guess by my presence here. I think arbitration is an efficient and less costly and obviously private way to resolve disputes. And my impression is that there isn't as much use of arbitration perhaps in the interior of BC as there is in the Lower Mainland. And that, I think, could be rectified, and so we'll speak to that a little bit. So the basic landscape of arbitration in BC, arbitration is a final dispute resolution mechanism, has its roots in the law of contract. Obviously, parties, in order to submit themselves to arbitration, need to enter into an arbitration agreement. So they need to agree to the process. Typically, the arbitration agreement is in the originating contract that gave rise to the dispute before any dispute arose. But parties are free to and often do agree to arbitrate their disputes as opposed to go to court after a dispute has arisen. So arbitration has its basis in contract. Now, each province has an arbitration act which confirms the legal validity of arbitration as an alternative to court. And most importantly, I think limits judicial intervention into arbitration decisions, which are called awards. That, I can tell you, having some experience practicing international arbitration out of law school, is important for the limiting judicial intervention for setting aside arbitration awards is important in the international arbitration landscape, for determining whether a jurisdiction is quote unquote arbitration friendly. And as I'll discuss in a moment, BC has moved in that direction very well through the new arbitration regime, which is more arbitration friendly and limits judicial intervention, is clear about when a court can intervene in arbitration versus when it can't. So BC got a new arbitration act in the fall of 2020. I think it was September. The act before had been in place for a long time and was kind of bare bones. It did what it needed to do, but didn't provide much clarity in terms of procedure and arbitrators' powers and whatnot. And most of the arbitration rules were actually drawn into the arbitration center's rules that were drawn into the act by default. So now those rules are in the Arbitration Act. The Arbitration Act is written in easy to understand language. It's been modernized very significantly and importantly harmonized with other jurisdictions. Our Arbitration Act is now based on the UN model law, which many jurisdictions around the world have adopted. Of course, our legislature changed it somewhat, but being harmonized in that way supports the predictability of arbitration in BC. I should be clear too, when I'm talking about our new Arbitration Act, I'm talking about the Domestic Arbitration Act. There's also an International Arbitration Act, which is beyond the scope of what I'm mainly going to be talking about today. So at the same time as we obtained our new Arbitration Act, which was a big step forward, as Barry mentioned, the BC International Commercial Arbitration Center, which had the mouthful acronym BCICAC, I think. I never get that right, but it rebranded to VanIAC, the Vancouver International Arbitration Center, and it adopted rules that complement the Arbitration Act. Those rules also, again, I'm talking about the domestic rules mainly in today's presentation, are very easy to understand and promote efficiency. And I'm leaving that part of the discussion to Joe and Laura, who will discuss all matters involving VanIAC. So I'll go over a couple key points about the new Arbitration Act as opposed to the old one. There's a lot of information, obviously, online that you can find when the new Arbitration Act came into force and VanIAC adopted its new rules. You know, every law firm in the land published a blog post which explained this really well and better than this, but I'll give you a taste of that, and you can go do your research if you want after. So primarily, the new Arbitration Act clarifies and streamlines procedures for commencing arbitrations, selecting arbitrators, and conducting arbitrations. It is much clearer on the rules of procedure than the previous Arbitration Act. It clarifies and I think broadens the powers of arbitrators in arbitrations. So it gives arbitrators specific subpoena powers for third-party witnesses. These are just examples. Allows the tribunal to appoint its own experts, to issue interim orders, such as injunctions, asset preservation orders, and to order security for costs, and to enforce the rules of equity. That was an interesting gap in the previous act, which it was unclear in some cases whether the arbitrator had equitable powers, but they certainly do now, and powers to order injunctions and issue subpoenas and all the things that you'd expect a court would be able to do to manage its process. Importantly, as I mentioned, the Act supports the certainty of arbitration awards by streamlining enforcement and clarifying and limiting the circumstances under which a court can intervene in an arbitration award. It also, on the flip side, it allows courts, it provides specific powers for the BC Supreme Court to intervene when desirable and necessary to promote the arbitral process. Like, for example, issue a stay of proceedings if a party to an arbitration agreement incorrectly or wrongfully sues in court, the other party to the arbitration agreement or another party can seek a stay of proceedings in favor of arbitration. The Act also has other powers for courts, for example, assistance with out of province subpoenas and things like that. So again, supports the certainty of arbitration by limiting judicial intervention when it's not desirable and providing for judicial intervention when it is. The new Arbitration Act designates VanIAC by regulation as the authority to resolve quickly interim issues and arbitrations that arise, such as most importantly, appointment of the tribunal, which is usually a single arbitrator but can be three, and payment of the arbitrator's fees. So those interim skirmishes don't derail the process, because the Vancouver International Arbitration Center, upon application, even if the arbitration, even if the VanIAC isn't administering the particular arbitration, you can still apply to the arbitration center to deal with those issues efficiently without having to go to court about it. And perhaps most importantly, it clarifies that arbitrations are confidential. Arbitrations have always, as a matter of course, been private and confidential, and that's one of the many benefits of having an arbitration versus airing your dirty laundry in the court process. But the previous act was silent on that, and now it's clear that arbitrations are presumptively confidential unless the parties agree otherwise, or there's some other higher reason to disclose information, such as under a court order. So that is, a brief overview of the statutory landscape in BC in respect of arbitrations. Now, I'm going to talk for a few minutes about my thoughts on the benefits of arbitration. This is coming from my experience of having practiced arbitration in multiple jurisdictions, and then coming back to British Columbia and having that set of eyes on it. So, obviously, as Canadians, we're obviously very proud of our court system, and we should be. The issue, though, is that the rules of court enforce kind of a one-size-fits-all standard on all cases. There's not really any room for amendment of procedures, and based on the type or size of case, the amount at issue, the identity of the parties, the location of witnesses, anything like that. So inefficiencies tend to abound in court. I mean, I don't think anyone on this webinar can dispute that. So with that background, arbitrations provide the following benefits. I'll go over some of them. I'm sure there's more. Obviously, you can choose your adjudicator. That's a big benefit because you can choose an adjudicator that has specific expertise in the subject matter and in the type of dispute and the type of legal issues in your case. That is maybe the biggest benefit of arbitration, in my opinion. Something that litigators, I think, don't think about very often is a huge benefit of arbitration is case management. In BC, I think not typical for cases to be managed by the final adjudicator from the beginning of the case. Obviously, as you go through a usual case, you go through your applications and your chambers practice, and every judge or master that you appear in front of is probably not going to be the judge who is the final adjudicator of your dispute, and that can lead to behavior on the part of counsel sometimes that counsel can behave in ways that they wouldn't behave if the same adjudicator was overseeing the entire process and knew what counsel is up to in all the pre-trial phases of the case. So now that comes actually from my experience. I think some of my colleagues at my firm, my partner Jeff Robinson, I think, is on this call, and he'll laugh because I've mentioned this all the time. But in US practice in court, cases are managed from the outset from a single judge. You get a judge right away. All applications go through that judge's chambers, and a judge will get to know that one of the counsel is misbehaving throughout the case, and that will not reflect well on that party when it comes to trial. So arbitration provides that benefit, and I think it's a big benefit. You have your arbitrator from day one. The arbitrator sets the procedure, oversees the entire process, and is going to be more up to speed as well when the case finally makes it to an arbitration hearing. Another benefit is that the arbitrator will tailor the procedural steps to only be those ones that are necessary and desirable in order to justly determine the dispute. So, obviously that's one of the main points of arbitration, is that it will limit inefficiency and delay. And presumably your arbitrator will be keen to do that. Along the same lines, an arbitration matter, now this isn't by any stretch universally true, but in most cases, arbitration can go a lot faster than a court proceeding can. It can be determined within months of commencement, even for complex cases, rather than necessarily taking years as it would in court. Similarly, the overall cost of arbitration is often significantly lower, even when factoring in the fact that the parties need to share the cost of the arbitrator and the administering authority, if there is an administering authority. As I mentioned, arbitrations are private, which is a big benefit, obviously, for not needing to raise to as I mentioned, wash dirty laundry in public. It also has the benefit often of keeping business relationships. If the parties are in a dispute, if business partners or contracting parties have a long-term business relationship, the fact that they're resolving their dispute through arbitration and everything is private and not public can help ensure that the dispute doesn't derail their entire business relationship. And that's another important benefit of arbitration. Of course, correspondence with the arbitrator and the administering tribunal usually takes place by email or phone, which is obviously more efficient than bringing applications in the court registries, and then waiting to get on and maybe not get on. You can just email the arbitrator and say, I'm bringing an application. Can we have a preliminary phone call? Let's talk about procedure and how, and when we're going to exchange materials, and you can set it down right there. Another point that's important in arbitration is usually, not always, but usually, I dare say the norm is substantial indemnity costs for that are awarded in favor of the winner of arbitration, which obviously has, that being the norm, that will seriously discourage unreasonable positions, either as an arbitration claimant or a respondent. If you lose, you pay. Arbitrators don't need to enforce the rules of evidence strictly. Of course, arbitrators are going to be guided by fairness and natural justice, and everyone needs to be heard, and the evidence, needs to be reliable. But the fact that the arbitrator has more flexibility than a judge would in court provides more leeway in presenting one's case and can overcome some of the burdens and hurdles that you have with authenticating evidence in court that is obviously reliable, but maybe can't be properly authenticated through a business records or whatever it might be. And then lastly, arbitrations are final, meaning that it's more difficult. For the most part, arbitration parties are stuck with the result that they get. It's rare, and it's going to become rarer now that BC has its new Arbitration Act for a party to be able to set aside an arbitration award if they don't like the result. Appeals can only take place on a matter of law, and only with leave of the BC Court of Appeal. So the appeal path to truly appeal an arbitration award because a party thinks the arbitrator got the law wrong, that goes to the Court of Appeal, and you need to get leave. And leave is only granted if really there's a possibility of a miscarriage of justice because of the law being incorrectly understood or applied by the arbitrator, or if the point of law has some kind of broader relevance to the parties or a class of parties or the general public. And parties can agree to forego all appeals at the outset, even on matters of law. Or now there's a new mechanism, which I think Laura will discuss, where parties can move their appeal from the Court of Appeal to an appeal tribunal within VanIAC. So I'll finish now. I realize I'm talking maybe longer than I should have been, but there's just a couple anecdotes from my own practice about the ways that you can craft an arbitration procedure that's extremely efficient in the circumstances. And there are mostly unlimited ways that you can do this, but that's one of the major benefits of arbitration, is that parties can counsel really can get together and determine what needs to happen in order to get this this dispute resolved. And it doesn't need to always look like a hearing that like a case where there's arbitration pleadings and then there's memorials and evidence and maybe you have some document discovery and then you go to a hearing. It can be more streamlined than that in appropriate cases. I have a couple files right now where counsel are moving toward what I think is referred to, I discovered later, is called MEDOLA, or mediation last offer arbitration. And this is an example of something that works. I've been employing it in cases where you'd otherwise be going to court to seek a winding up order or liquidation of a company where shareholders are fighting about who gets what and what the share valuation is. Somewhat like an oppression proceeding, but with less factual disputes. In a case like that, I've been participating and have set up these procedures where everyone agrees that this case is going to go to mediation first, and the mediator is going to serve, and the arbitrator who you pick is going to serve as the mediator. So the arbitrator is going to learn a lot of without prejudice information, and everyone agrees that's okay. It's not always okay, but if everyone agrees it's okay, and your arbitrator is okay with it, it's okay. And if the mediation is not successful, then the parties go to another phase where the mediator takes off the mediator's hat and puts on an arbitrator's hat, and now is the final decision maker. And each party at that point will submit their final offer to the mediator, or to the arbitrator, sorry. And the arbitrator will usually just pick one of those final offers after having considered the parties' arguments as to why that offer should be accepted over others. You could even get rid of, in some cases, you can go to a direct baseball arbitration, which Joe had mentioned earlier when I was preparing for this. And that is a situation that it's called baseball arbitration because it's used in the major leagues when a player can't agree with salary with the team. And basically each party submits a final offer to a neutral, to an arbitrator, and the arbitrator and then argues why their offer is the best offer, and the arbitrator must pick one or the other. So that obviously brings people to the middle from the very outset and is extremely efficient. Now, these are just examples. The point really I'm trying to make is that there are ways that arbitration can be massively efficient. And in the appropriate circumstances, with the cooperation of counsel, you can determine things much quicker than you could in complex cases in court. So that wraps up my comments. I went over time. I promised I would, my fellow panelists.
Thanks, Jordan. So I'm going to be talking about VanIAC's expedited procedures provisions, but I just want to situate people who may be less familiar with arbitration as to what we're talking about. So as Jordan mentioned, there's the Domestic Arbitration Act, which by law governs your arbitration. And then the parties can choose to use institutional rules like VanIAC's rules or rules of their own choosing in order to add process to the arbitration. So typically the way an arbitration comes to VanIAC is that that's specified in the contract at issue in its dispute resolution process, but parties also can choose to specifically, once a dispute arises, to use VanIAC's rules. And that is something that we're seeing with respect to these expedited procedures that I'll talk about, because they are really efficient and they provide parties with a cost-effective way to resolve smaller disputes outside of the courts. So what I thought I would do is walk you a bit through when these rules apply and how an expedited procedure process typically runs, because we've in other seminars talked a little bit about these, but I wanted to get into some more detail today. So when do the expedited procedures apply? Well, they apply if parties have agreed to use VanIAC's domestic arbitration rules and no claim by either party exceeds $250,000, including interest and costs. So if you've agreed to use VanIAC's domestic rules and you're below that threshold, they will automatically apply. or they may apply if the parties agree specifically to use those rules. But they won't apply if the parties have agreed that there should be a panel of 3 arbitrators. So if you've agreed that VanIAC's domestic rules should apply, your claims are under $250,000, but your dispute resolution clause says that it will be heard by a panel of 3 arbitrators, you won't fall within the expedited procedures. Parties can also have agreed to opt out of those procedures. And VanIAC can also determine prior to appointing an arbitrator that the matter is not suitable for expedited procedures. So assuming it fits within the procedures, from a practical perspective, VanIAC will flag the applicability of the rules once a notice of arbitration is filed and the proceeding is commenced. And this is sort of what Barry alluded to at the beginning, that VanIAC is, you can think of it sort of like a court registry, but a bit more interventionist and accessible, and that they will identify, for example, what rules it seems that you're under. They will remind you of timelines, and they are copied throughout the dispute and follow up with the parties as needed. So once it's identified that it falls within the rules, VanIAC then assists the parties to get the arbitrator appointed and has the initial correspondence generally with the arbitrator. If the arbitrator accepts the appointment, they are agreeing to a flat fee arrangement, which is approximately $5,000 per claim or counterclaim if the dispute is under $100,000, or $10,000 if it's under $250,000. So if you've arbitrated a large dispute, or maybe even a not so large dispute, you know that this is a very good deal on arbitrator fees. And this is one of the key features of the expedited procedures that makes it so attractive. And an arbitrator can obviously decline an appointment if those terms are not acceptable to it. Once the arbitrator is appointed, like any commercial arbitration, the arbitrator will then convene a procedural conference to discuss aspects of procedure that are not covered by the rules, such as the timing and format for exchange of written material. So again, this is what Yarden referred to, in that with an arbitration, you have continual case management and the parties work together to decide on the process. On that point, I would also add that one of the important features of the expedited procedures are that it's primarily a hearing in writing. So the parties will exchange their argument, documentary evidence, and sworn or affirm witness statements. And that is the exchange of submissions, evidence, everything in the proceeding. And in total, that exchange must be completed within 90 days, unless the parties and the arbitrator otherwise agree. So in the matters I've been involved with, there have typically been a couple of rounds of exchange. So you can imagine it's quite a compressed timeline. But in my experience, this has really motivated the parties to be efficient, and the quality of the submissions, I don't think, has suffered as a result of that compressed timeline. So once all the material has been submitted, then there is an option for either party to apply for an oral hearing within 5 days of the last material being submitted. And if neither party applies, which in my experience has generally been the case, then the arbitrator has 30 days to issue their award. So you're looking at a period of about 120 days to have the whole proceeding decided. If a party does apply for an oral hearing, the arbitrator is only to order an oral hearing if they're satisfied that it is necessary, having regard to the arbitrator's duties under Section 21 of the Domestic Arbitration Act. And those duties are to treat the parties fairly, give them a reasonable opportunity to present their cases, all while trying to achieve a just, speedy, and economical determination of the proceeding on its merits. If a hearing is ordered, it is restricted to 1 day, absent extraordinary circumstances. And it's really intended for any cross-examination on the witness statements that's necessary and any necessary oral submissions. If an oral hearing is ordered, the arbitrator is paid a prescribed hourly rate for the hearing. And then at the conclusion of the hearing, the arbitrator has 45 days to issue their award. A couple other points about these processes: the arbitrator has jurisdiction to seek to have oral submissions, to extend deadlines, and to order that cross-examination and oral submissions take place by telephone, video, or in person. So there's flexibility as to format. And there are no appeals from expedited procedure awards unless consented to by both parties. How are these working so far? These have been very popular. We're seeing a lot of these come into VanIAC. The parties are getting quick resolutions. They're finding them to be cost effective, both in terms of arbitrator fees and compressed counsel fees, because it's a shorter period of time. And we anticipate at VanIAC that there will be further increased use of them. On the arbitrator side, I think arbitrators are finding that it's a lot of work for the flat fee, but it is fulfilling one of the goals of these, which was to be able to give a more diverse group of arbitrators an opportunity to get experience. So an arbitrator who has been sitting for 20 years may not choose to do this, but newer arbitrators, they may be willing to do it and get the experience, and the parties get very high quality arbitrators that are well vetted by the organization as well. And then one final tip I would give for arbitrators and parties moving into these procedures is to make sure that you develop a procedure to ensure that the award that the arbitrator issues can in fact be a final award. So that award that's issued at the end of the 30 days should be an award that deals with all matters, including costs, interest, etc. Otherwise, a partial final award is issued with costs and other issues to be determined subsequently, and this timeline gets pushed out and there may be additional expense for the parties. I've seen them done both ways, and that definitely becomes less efficient. So that is a brief tour of the expedited procedures rules. And with that, I will turn it over to Joe to discuss virtual procedures and his perspective on those, both as counsel and as arbitrator.
Thanks very much, Laura. And maybe before I start on virtual hearings, I'll just follow up on a point that Laura made about a final award. And just for those who have less experience with it, and I know sometimes counsel are surprised, but in the usual international practice is to make your submissions on costs, but at the same time you make your final submissions or shortly thereafter. So before you actually have the outcome, you make your submissions on costs, which might be something along the lines of the successful party should be entitled to their costs. And here's an outline of what our costs are, our actual costs, as Jordan said. You set out your actual legal fees that we spent on our lawyers, and that's what if we're successful, that's what we would like to get. So you have those submissions before the tribunal, before they do the final award. So there's only one award. The other way, which domestic arbitrations and court, when we're comfortable with, is your traditional way of getting cost submissions after the award is done. And as Laura said, it takes a longer time and you're adding additional submissions. When you're trying to do this compressed approach, the international approach of having your cost submissions made before the final award is probably a little more effective and ensures you get the final award. So
yeah. Sorry, Joe, just to add on that, sometimes parties are a little bit concerned about privilege and how that may come into play in disclosing their costs. But the way this is done typically is by having lead counsel certify a breakdown of the costs without actually providing the timesheet. So there are ways to do it that cover those concerns.
And usually what we recommend is for arbitrators is dealing with the issue of costs and how costs will be dealt with should be dealt with at the front end at the procedural conference before anyone has a sense of which way the winds are blowing in the arbitration. It's good that everyone knows at that point in time, here's how we're going to do it. And we're agreeing to it at this point in time so we know how it's going to work, so people don't throw up roadblocks at the end. I'm going to speak very briefly on virtual hearing procedures. And, you know, at one time, a very esoteric kind of discussion, maybe not so esoteric, but maybe a little bit. And now, of course, here we are 2 years of doing this sort of Zoom presentation, 2 years of of doing arbitrations mostly by video conference. So it's not so esoteric anymore. But really, and even in arbitration, long before COVID-19, arbitration proceedings were regularly using telephone and video for all or part of hearings, including for witness cross-examination. And this really is part of a natural progression of what arbitral tribunals traditionally have done. And that's as part of their practice to hold arbitration hearings in more than one place where it makes sense. Particularly in the international context, it wouldn't be uncommon to have an arbitration seated in London, but go and take a week of evidence in Paris or in Moscow or wherever it happens to be. If there's a whole bunch of witnesses that are in that place, so that wasn't uncommon, particularly in the international context. And so, really, unlike a traditional court, arbitration hearings have never been tied to the legal seat of the arbitration. They traditionally have been held anywhere, and as technology has advanced, for the most part, by any method. And really, as things progressed, arbitration picked up, web-based video conferencing pretty early on. And before COVID, it was very common to have a number of witnesses testify by video. In the last two pre-COVID hearings that Laura and I were both involved in, one was in December 2019 in London, and one was in February 2020 in Vancouver. We had numerous witnesses attend for cross-examination by video. COVID was not the issue, obviously. It was just cost and convenience. The London one, for example, had witnesses from all over the world, and it made no sense to bring someone from Australia, for example, for a 20-minute cross-examination. So that was done by video. Others, where it was more convenient, were there in person. So even pre-COVID, when we were looking at amending VanIAC's domestic arbitration rules, we knew that we were going to include provisions that provided some guidance on virtual hearings. And what we tried to do in the Rules Committee when we were drafting the domestic rules was try to formalize at least some best practices for virtual hearings and provide at least a framework for the parties and the arbitrator to consider procedural issues that may arise during virtual hearings. And we wanted to ensure that COVID or not, another pandemic or not, or whatever the case is that requires virtual hearing, we wanted that the use of virtual hearings be considered for all arbitrations. So there's a requirement in the rules that the parties in tribunal consider, right at that first procedural conference that Laura was talking about, consider the use of some or all of the virtual hearing procedures really at that first procedural conference. Consider how those can be used to make the arbitration more efficient. And I think it makes sense, because if you have an arbitration with witnesses outside of British Columbia, outside of Canada, or a domestic arbitration that has witnesses just scattered around British Columbia, it won't always make economic sense to bring them together in one place. It depends on the amount involved, the witness convenience, etc. But what we've done is provide some sort of a framework and ensure that parties are thinking about it and the tribunal is thinking about it right at the front end. How can we make this arbitration as efficient as possible by using some of these virtual hearing procedures? So in terms of the framework, we've set out, some of the best practices to consider are set out in the rules, but we've given the arbitrator and the parties flexibility. They don't direct the arbitrator and the parties how they're going to do the virtual hearings, except what they do is they say to the arbitrator and the parties, in setting up your virtual hearings, you need to consider these things, and these will apply unless the arbitrator or the parties decide otherwise. And as many of us have learned over time in dealing with virtual hearings, there's a number of practical issues that arise that you may not think of at the front end. And that's what that kind of list of framework issues is meant to identify. Here's some of the things you need to think about before you launch into your virtual hearing. And I think for the most part, those are really helpful. So if you're thinking about how you deal with documents during the virtual hearing, witness statements, expert reports, how do you deal with new documents that someone says, I've got to cross-examine on this new document? How do I get it to everybody? How do we deal with that? Those are the types of things that you're meant to address before the hearing so that you're prepared during the virtual hearing for that eventuality. Now, from time to time, there's reluctance on the part of parties or counsel sometimes to have virtual hearings. And it's possible that an arbitrator may have to rule on the matter. And so I had an arbitration where the parties had agreed in their arbitration agreement that the arbitration would be venued in Kelowna. And the initial procedural order, that was what was set out. But that was pre-COVID when the initial procedural order was done. And when COVID reared its head, there was a very real issue in terms of both travel and holding meetings of a certain size. And there was a concern that if the matter was still set to be heard in Kelowna, for example, that the hearing wouldn't be able to proceed because of these restrictions. We wouldn't be able to do it in person. And so the issue came back before me as arbitrator, and I took submissions from the parties, but I said that it made sense, subject to the submissions, that we have the hearing by video rather than in person, given the COVID restrictions. And one party objected to that. And they said, well, a video hearing, a video cross-examination really substantively diminished their opportunity to present their case. I mean, it was, the argument from the lawyer was, I want to be able to look in the white of his eyes of the guy that I say is lying and say to him he's lying. And that's going to make a difference in terms of credibility. And it's going to make a difference to you, arbitrator, be able to look at him, be in the same room as that person, and decide whether or not they're lying. And so I think it's kind of an interesting question. And I found that on what was before me, there was no evidence that there was a difference in assessing credibility between examination in person and video examination that suggests that credibility is necessarily best assessed in person as opposed to video. And my ruling in that case was that based on the evidence before me, there was no reason to think that either party was having their opportunity to present their case diminished in any meaningful way, and that balancing off all the other considerations of going ahead and doing it by video would really be in both parties' best interests. And so I ordered the arbitration proceed by video. It did. I think it went well. There weren't any particularly large issues other than the occasional connection issue that comes up from time to time in these things. And in fact, the party that objected to the video hearing ended up enjoying at least a modicum of success. So, I think that's consistent with what there's been some court rulings with respect to video hearings as well, as to whether or not they were a breach of natural justice, and the courts have, I think, almost unanimously held that they're not, and that matters should still proceed. That being said, I think at least for me as counsel and as arbitrator, I really strongly prefer to do arbitrations in person. And I think I can't come up with a really good reason for it though, beyond the fact that I find it much more fun, because I find this job to be fun, sitting as counsel and sitting as arbitrator from time to time. And frankly, it's much more fun to do it in a room full of people and have breaks with people and so on. I just find it more fun. That's a hard sell to a client and a hard sell to parties that we should have it in person, because I find it much more fun. But so at least in my experience, both in sitting as an arbitrator and doing these or acting as counsel, there's rarely a strong reason why a hearing must proceed in person, particularly domestically. Sometimes when you have witnesses around the world, the video conference cross-examination is difficult. If you've got one witness in Japan and the same day you want to have a witness in the Czech Republic, the time zones become a bit of a mess, and it does make some sense to kind of find a central location that might make sense in terms of time zones. But that's the only situation where I think there might be a strong reason to have it in person. Those are my views. Others have different views, but I think what we've done in the VanIAC rules is at least ensure that people are considering these issues at the front end when looking at setting up their initial procedure order, and then we've got a framework for how to consider the issues when it comes to actually holding the hearing. So those are my thoughts on the virtual hearing. And Barry, I think it's back to you in the event there's any questions that still remain unanswered in the chat, or people can add additional questions in the chat.
Great. Thank you, Joe. Yes, and I should say one of the questions that came up early is something I forgot to mention at the outset, and I should have, which is that this webinar is eligible for up to 1 hour of CPD credit through the Law Society of British Columbia. It typically takes a day or two for that option to show up on their drop-down menu when you go in to record your CPD credits. But yes, it should be eligible for up to 1 hour of CPD credit. The question came up, someone mentioned that they've been involved in a case where they're waiting an extended period of time for a decision, an award from an arbitrator. That is, my view, rather exceptional case, the length of time that you're waiting. I understand there's some unique circumstances there, apparently a health issue affecting the matter somewhat. But yes, we do monitor how long it does take for a decision or an award to be rendered. And definitely the panelists, the arbitrator will be hearing from us as we try to keep everybody on track and on task to meet the timelines that we set out to achieve.
It's also not uncommon to have sometimes in the arbitration agreement itself, there already be some set dates, which tend to be extremely unrealistic, but sometimes those are already set out in the arbitration agreement in terms of when the award must be issued. And oftentimes you can raise that issue as counsel. You can raise it at the front end at the time of the initial procedure order. And that would be similar. Jordan mentioned his experience with ICC proceedings, and certainly in the ICC, they actually require that as part of the procedure order, that there's a date for when the award must be issued. They've got some different procedures that are different than ours, but there's no reason why that can't be part of the initial procedure order, because that is kind of an exceptional period of time. With the expedited rules that Laura was talking about, there is a set period of time. So it's already set out in the rules that the award must be issued by that time. So the arbitrator doesn't have discretion unless the parties give them some discretion, him or her, that discretion at the time of the conclusion of the hearing.
Thank you for that. Just noting the time, we have a few minutes left. If there are any additional questions, please let us know. Jordan, Laura, or Joe, is there anything else that we should address? Maybe not putting on this spot, but could you remind me, what is the timeline for a decision under our expedited rules? When should an award be rendered after the hearing?
So it's, if the hearing is just in writing, it's 30 days after the last material is submitted. And if there is an oral hearing, it is 45 days after the oral hearing.
Thank you, Laura. And I may have been remiss in my introduction of Laura. I mentioned that she's been helping us draft our new rules, and that shows with her knowledge. But I may have forgotten to mention that she's also a key member of our board of directors. Thanks for that, Laura.
I wanted to make a couple additional comments that came up as I was listening just before we stop. Is that okay, Barry?
Yeah, I see we have another question
Okay.
about consequences for a party that fails to meet delivery deadline under the expedited rules. And just before turning it over, I know that John Orr QC in Victoria was asking about registrations or participants. My understanding is we have more than 60 people attending right now, participating in this webinar. Go ahead,
So I could start on the consequences. I think the biggest power that the arbitrator has, assuming the parties haven't otherwise agreed to how costs will be allocated, is their discretion with respect to costs. So if there has been, if one party is adding to expense or time of the procedure, then that might be reflected in the cost award at the end of the day. The arbitrator has significant discretion, again, depending on whether the parties have agreed otherwise with respect to costs. So that could be one potential consequence.
Thank you, Laura.
Sorry, Barry, there was also a question about when cost submissions should be made, whether they should be made with the procedural hearing. And I would say in terms of the process for costs, yes, that should be, as Joe mentioned, that is something that should be dealt with at the beginning, at that initial procedural conference. The parties and the arbitrator should discuss how cost submissions will be, the format and timing of those, and then that can be reflected in what's issued from that procedural conference, which is generally referred to as a procedural order.
Good point. Yarden, I think you had something more you were going to say, or what?
Yeah, one point that came to mind is model arbitration clauses on the VanIAC website. It has model clauses for insertion into agreements. That I'd encourage everyone to take a look at them if you haven't already, and to the extent that there are solicitors in your firm who are seeking out arbitration clauses or would be open to using them in their agreements, I'd like to say that you should seriously consider inserting one of those clauses into your contracts. If you're contemplating an arbitration clause, or even if you're not, it's something that maybe folks can turn their minds to. On the same point, I just wanted to mention that dealing with the VanIAC staff, I have a little anecdote. My legal assistant, who was new at the time, new working for me anyway, and I had an administered arbitration with the center in its old name, the BC International Commercial Arbitration Center, and she was just continually blown away by how friendly and efficient and responsive the registry was. That has been my experience. I think they've been absolutely wonderful, and that's not to take anything away from our court registry staff, but the level of service that you get is really exceptional. I just wanted to mention that. And
thank you, Yarden. On behalf of our staff, yes, we appreciate those comments, and we do all work hard to try and service people who use the center. Just noting that we're getting close to wrapping up, I'll take this opportunity for those that are still plugged in to let you know we have another webinar coming up next week, Monday, same time, 12:30 p.m., dealing with ICBC arbitration. For those that may practice in the area of personal injury law pertaining to motor vehicle accidents, you may or may not know that ICBC does have a pilot program currently using VanIAC, the Vancouver International Arbitration Center, as an alternative to the courts for a certain select number of cases that have been delayed in court. We know that the courts stopped doing in-person hearings again in January due to Omicron, but even without that, there are court delays and problems with multiple trials booked at the same time. So ICBC, working with VanIAC and the Minister of Attorney General, we have put together a pilot program. And if you'd like to learn more about that, tune in next Monday at 12:30 p.m. If you want more information, feel free to contact the VanIAC office. You can visit our website or just Google us, and feel free to send us an email and phone us, and we'll get you registered for that free webinar next Monday, February 7th at 12:30 p.m. on ICBC arbitration. And with that, and noting the hour, I'd like to thank everybody, especially our panelists, but you, our viewers, for tuning in and learning more about arbitration and how we can help resolve disputes in a timely and effective way. I hope you have a great day. Thank you very much.
Thank you.